This is a review of the case Favia versus Indiana University of Pennsylvania, which was a landmark Title IX case. Plaintiffs are Dawn Favia, Wendy Schandelmeyer, Kim Del Camo, and Amy Fehler on behalf of all present and future female athletes of the Indiana University of Pennsylvania. The defendants of the case were Dr. Lawrence Pettit, the school's president, and Frank Signetti, the director of athletics. The facts of this case: Indiana University of Pennsylvania, also known as IUP, was a federally funded educational institution. In the 1990-1991 school year, it had 10,793 students enrolled. Females accounted for 55.6% of the enrollment. In 1991, it faced a budget crisis. Both state and federal funding was being reduced, so all departments, including the athletic department, had to find ways to decrease their budget. The athletic department needed to find a way to decrease it by $350,000. In the 1990-91 school year, there were 18 varsity sport teams, 9 women and 9 men, 18 club teams, and 44 intramural teams. There were a total of 503 athletes. 62.2% were male and 37.8% were female. Total athletic scholarship money was $314,178. Of that, 79% went to male athletes and 21% went to female athletes. The AD recommended cutting women's gymnastics, women's field hockey in 1991, followed by cutting boys soccer and tennis in the 92-93 school year. After eliminating the 4 teams and normal attrition of football players, there was 397 athletes, 63.5% male and 36.5% female, which was not much change in percentages prior to the cuts. The plaintiffs in this case sought for a preliminary injunction to have women's gymnastics and women's field hockey reinstated and to prohibit the defendants from eliminating more women's teams. They argued that the university fostered athletic disparities and participation opportunities on basis of gender, that there were disparities in levels of support to male and female athletes, the allocation of athletic scholarships was discriminatory based off of gender, and because of these things, they were in violation of Title IX. The defendants argued that the cuts were necessary because of the decrease in federal and state funding, that they equally cut 2 male and 2 female sports teams, that the NCAA did not sponsor the gymnastics championship competition, and that women's gymnastics and women's field hockey were no longer viable. They intended to elevate the women's soccer to a varsity team as soon as the budget allowed. Ruth Pabilski, a former associate director of athletics, expressed her concern in writing to the president of the school and had conversations with the president of student affairs and the director of athletics. Her concerns were that women's sports have always been less of a priority than male sports, that the condition of the baseball field was superior to the softball field, and that the proposed cuts would be a violation of Title IX. Christian Grant, an expert in the area of equality, after reviewing IUP's situation, recommended the following: 1. Reallocating resources. 2. Appoint a committee to draw up a 5-year plan. And 3. Immediately reinstate women's gymnastics and field hockey. Given the 3-pronged test for compliance in Title IX, IUP clearly failed the first prong. Participation opportunities was not proportional to enrollment by gender. 55.6% of the student body was female, yet 36.5% of athletes were female. They also failed the second prong. In the recent past, they had not elevated or expanded opportunities for women. On the contrary, they eliminated opportunities and went from 10 female varsity sports down to 7. They also failed the third prong. They did not fully and effectively accommodate the interest and abilities of the women at IUP. The promise of varsity women's soccer did not warrant compliance. The court ruled in favor of the plaintiffs. They found that Indiana University of Pennsylvania was not in compliance with Title IX. They did not fulfill any part of the 3-prong test. the court ruled that the women's gymnastics and field hockey be reinstated. Implications of this case. Title IX cases can be violated without a person or university showing an intent to discriminate against women. IUP thought they were doing the right thing by cutting equally 2 male sports and 2 female sports. However, they were still in violation. This case also says legislation that being financially strapped does not justify cutting women's sports and or is an excuse to not be in compliance with Title IX.